are you Mr. Van Hoos there on the screen marked W. Evans? Okay, there it is. All right. Okay, this is case number 21-0172, State of Ohio versus Brian Lee Van Hoos Jr. You are Brian Van Lee Hoos Jr. appearing on the screen, marked W. Evans.
Yes, sir.
Okay. All right, this hearing is being conducted by Zoom. The defendant's attorney is Jacob Wagner, appearing from his office, appearing on behalf of the state, is Assistant Prosecuting Attorney King. The defendant is charged with breaking and entering, breaking and entering, theft, and impersonating an officer, a peace officer. And the matter was set today for a hearing on an intervention in lieu of conviction plan. The court has received a proposed plea and entry, and you're currently at the counseling center campus there in West Union, Mr. Van Hoos.
Yes, sir.
Okay. All right. Let's see. I have the questions that were signed by the prosecutor on the 16th of March, are submitted with the entry. And I have this plea of guilty form, an entry granting intervention in lieu of conviction. We'll hold this up to the screen, Mr. Van Hoos, but it looks like you signed this back, it was faxed to me on February the 10th. Well, I'm not sure if that was faxed to Mr. Wagner or not, but anyway, whatever date, but here is the form, and you recognize that, your case name, the plea and intervention, first page there.
Yes, sir.
All right. And then on page 3, there are signature lines, and there's a sentence right at the top of the page that says, I enter this plea voluntarily, and then right below that, there's a signature defendant that looks like Brian Van Hoos' signature to me. I'll hold that up to the camera, and there's actually a signature there at the top of the page on that line.
Yes, sir.
Okay. And you remember when you did sign this, Mr. Van Hoos?
The date?
Yeah.
I can't remember the exact
It was back in February, Mr. Wagner?
I believe so.
It's been quite some time. I'm looking, I got a record from Brian. But that was from like February 1. So yeah, it's been in February.
Okay.
It's been some time now.
All right. So this, well, and before we go on, since you're not in court with your attorney, if you need to talk to him at any time, you just let me know, and I can put you and him into a breakout room with just the two of you. Able to speak to each other, no one else will be able to see you here, okay?
Okay.
And then also, Mr. Wagner, you and your client are both waiving his appearance personally in front of the court and agreeing to this hearing being conducted by Zoom.
We are, sir. I should say, I'm trying to get over Brian today. I think there's some phone problems down at the counseling center. I finally got through, went to a voicemail. Brian, are you fine with the communication you're doing now, bud?
Yes, sir.
Okay. All right. So this agreement states that you're going to withdraw your not guilty plea and plead guilty to count 1 of the indictment, the breaking and entering charge under 2911.13a revised code, a 5th degree felony. Further states that you understand that the maximum penalty for that could be 12 months in prison if prison terms that are proposed. 6 months would be the minimum. There would also be a possible fine of $2,500. You understand that?
Yes, sir.
You're not facing any felony charges in any other jurisdiction.
No, sir.
You're not on felony, probation, community control, parole, post-release control in any jurisdiction.
No, sir.
Now, Mr. Van Hoos, I'm sure that your attorney went over this with you, but when you signed this agreement, did you understand it's an agreement to plead guilty, which means there won't be a trial, and the next step would be with the court to determine, put you into the intervention program?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision to sign this document?
Yes, sir.
No pressure to rush in any way in doing it.
No, sir.
Is it your decision to stand by this agreement, even though it's been several weeks past, and go forward with it here today?
Yes, sir.
And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
Right? Now, just to give you an explanation for the record, so it's clear that you understand what it is. Normally, when somebody is convicted of a felony, Mr. Van, who's the court files an entry stating that they were found guilty, and then there's a sentence. And the sentence could be, as I said, could be a prison term, could be a fine, could be community control, which is like his probation, or some combination of those. And then that means that that person does have a felony record once they have been sentenced. But until you've been sentenced, you don't have a conviction. So there is a procedure that's being utilized here that's called intervention to a conviction for persons who have committed offenses resulting in part or whole due to substance use disorder or mental health issues. And what that is that if that person is in a certified treatment program, which you are, they are then permitted to plead guilty but not be found guilty. What happens is the court basically stays the case and goes inactive. And what that means is it's not going any further. And I wait for a report from the probation department and the treatment providers that you have completed your program. Now, the court can put somebody in this program for up to 5 years. I usually put them in 2 years because I figure that's enough time to determine if that person is going to be successful in their effort. And what happens is you're put under supervision of the probation department under terms that are much less strict and comprehensive than if you were found guilty and placed on community control. You're also required to complete your intervention plan. And that means completing your residential treatment, any aftercare that's recommended. And then also, there's a requirement that you abstain from using alcohol or drugs for a period of 1 year. And that's all part of your condition. Now, in the event that you successfully complete your treatment and do all the things you're required to do to pay the court costs and so forth, then at that time, the case would be dismissed. So even though you entered a plea of guilty, and if somebody looks at the file and says you entered a plea of guilty, you're not convicted. So you don't have a felony conviction until you are sentenced. And so during this 2-year period, you're not a felon. You're not a convicted felon. And if you successfully complete everything, as I said, then at that time, when the court receives that notice, the charge issue will be dismissed, even though you pled guilty. And then at that time, the court will set a hearing to seal the record, and in all likelihood, would seal the record, and then it would no longer be part of the records of the court that are available for public view. Now, so that's the advantage of you. The disadvantage is this is the last chance that you have to stand on a plea of not guilty. And so if you plead guilty and don't succeed, then at that time the court would be notified by the probation department. There would be a hearing where they would have to prove that you haven't complied. And then at that time, you would not be able to say, okay, I want to have a trial now, because that time is already passed. That's what we're here for today, to say you want to go back and enter the program. And so if that were to happen at that time, the court, if the court found that you did fail to comply, could then terminate you from the intervention program, find you guilty, and then you would be subject to being sentenced, as I said, to 6 to 12 months in prison, $2,500 fine, and that could take place. Now, it wouldn't have to, because even if you don't complete the program, when we come back, and if I decide that you violated it, I would have ordered updated the pre-sentence report, and at that time, you can still be given what's called community control, which means that again, it could be up to 5 years. Normally, it's a 3-year term. And those conditions are much stricter and are more lovely. So that's the advantage and the disadvantages to you. You understand that?
Yes, sir.
Okay. Now, and the community control would work the same way in that if you were alleged to have not comply with those conditions, then they would file a written notice out of the court, and you would have hearing and be represented by an attorney, and at that time, the court would then revoke your free control if you violated the conditions, and then sentence you to prison for 6 to 12 months and fine you $25. You understand that? Okay. Now, the charge in count 1 alleges that you, on or about November 7, 2021, in this county, Samuel McKee, you, and Harold Kramer and Solana Kinzer did knowingly by force, stealth, or deception trespass in an unoccupied structure with an empty house at 3853 State Route 136, Hillsborough, with the purpose to commit an theft offense as defined in ORC Section 29130281 for felony, violation of Section 2911.13a, the higher vice code. So that's breaking and entering section. Now, you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged it?
Yes, sir.
I need to back up. I forgot to explain that in the event that you should be, at some point in the future, sentenced to prison, then, upon completion of that prison term, the law provides that the adult parole authority may, at their option, put you under post-release control supervision for a period of up to 2 years, which means you be supervised by a parole officer. And if they determine that you failed to comply, then that they can return you to prison, they can serve an additional period of up to 1/2 of whatever prison term was imposed for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you to an additional period of 1 year, whatever time's left on the period of post-release control, whichever is greater. And that period, that would have to be served consecutively to the sentence in the new case. You understand that? Okay. Now, have you discussed the nature, well, first of all, you understand the charge and possible penalties for the offense.
Yes, sir.
And you understand what the state says you did, when, where, and how they alleged that you did it.
Yes, sir.
Now, have you discussed the evidence of the case, possible legal issues of the case, possible defense you can try to raise at trial, possible outcome of the trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, other than the agreement that you enter plea guilty to count 1, the state dismisses the remaining counts and recommends intervention in lieu of conviction, and you'll have to make full restitution and cooperate against co-defendants. That's what's set forth on page 2. Has anyone made any other promises to you?
As far as,
In order to get you to make a guilty plea, other than what I just read to you, anything else been promised to you?
no, sir.
Do we know what the restitution amount is yet, Mr. King?
There's no restitution, Your Honor.
Okay, all right. So, there wouldn't be any restitution required, but you would have to testify truthfully if required to do so in prosecution of the other defendants. You understand that?
Yes, sir.
Okay. Now, do you hold any license or certificate from any state agency that regulates any profession or occupation?
No, sir.
You have certain rights you need to understand before you accept a guilty plea from you. You have a right to have counsel. Mr. Wagner's appointed to represent you. That wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you wish to provide. So if you decide that you don't want to do this, that you want to defend this case, you'll still be represented by Mr. Wagner. He'll defend you, including a trial, if that's what you want. You understand that? All right, now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that reside in this county that are summoned for jury duty under your trial date. After they're selected, the evidence will be presented, then the court will instruct them on the law, and then that jury will decide by unanimous verdict between all 12 and have to agree as to whether or not the state proved your guilt by proof beyond reasonable doubt. That verdict would have to be unanimous between all 12 and have to agree. You understand that? Just give me a second. Okay. This other case, Willis is in jail. Okay, they have not qualified. So, and that's JD's one. All right, sorry about that. but you didn't want to plead guilty, you can waive, which means give up in writing, the right to have a jury trial. In which case you would have a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would be the one who would apply the law, decide whether or not to state truth, you have to prove beyond reasonable doubt. You understand that?
Yes.
All right, now under the Constitution, you have a right to confront witnesses against you in court and to cross-examine through your attorney. What that means is the witnesses against you have to come in court, testify in front of you and your attorney and anyone else who's present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of which would be to bring out evidence and help your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use power of this court to compel or force witnesses to come to court and testify for you, just like the state. So if you have witnesses you're not certain whether to do voluntarily, at your request, the court issues a court which is called subpoena. That forces those witnesses to come to court and be able to testify, even if they don't want to be here, which is the same way the state's witnesses are forced to come to court. Do you understand that?
Yes, sir.
Right now, in the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can, the judge can. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time. In fact, no one's even allowed to talk about it, except in one situation, that is, if it's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you are presumed innocent of this offense until proven guilty by the state of Ohio and every essential element of the offense charge. So what that means is that you don't have to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not even required to present any evidence in your own defense in trial. You may, but you're not required to. Whether you do or not, burden of proof will remain upon the state to prove your guilt or prove beyond a reasonable doubt in every essential element of the offense charge, which is the highest burden of proof that we know under the law. You understand that?
Yes, sir.
Right now, originally entered plea not guilty. That plea denied the allegation of the indictment, denied committed any crime, and exercised revoked all the rights I just described. If you change your plea from not guilty to guilty, that plea is the opposite of the not guilty plea, as to count one. The guilty plea will admit the allegations in that count, admit that there are crimes, you committed that crime. And that plea would waive or give up all the rights I've described for you today, except the right to have an attorney. You always have the right to have an attorney no matter what you plead. Well, with that exception, you're pleading guilty. Waive or give up the right to have a jury or court trial. Waive or give up the right to confront witnesses against you and cross-examine through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to be here to testify for you, just like the state. Waive or give up the privilege against self-incrimination because you're saying you're guilty. And it would waive or give up your right to require the state to prove your guilt, prove beyond reasonable doubt. Because if you say you're guilty, they don't have to prove your guilt. And it also subjects you to being sentenced immediately by the court, which won't happen, but it is one of those things. And finally, it allows, or it waives, it gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence in this case, for under certain limited circumstances, you can file an appeal that would have to be filed in 30 days for your sentencing to be filed. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right, now, do you have any questions about the intervention program, or what's required of you, or what the consequences of that be if you go into that program?
If I have any questions, I'm able to call my attorney, right?
You want to talk to him now?
Yeah.
Okay, no problem. Are you Chad Burgess there at the jail? Okay.
Recording in progress.
All right, this is case number 21, CR 140. State of Ohio versus Chad Burgess. Mr. Burgess is appearing by Zoom from the Justice Center. His attorney is Danielle Witt. She is president of her office and representing the state's attorney Collins. Ms. Witt, you and your client both stipulate to his appearance for this proceeding today by Zoom rather than in person in the courtroom. Thank you. You're all right with that, Mr. Burgess? Yes. All right, Mr. Burgess is charged with aggravated possession of methamphetamine 53 felony. That was set for trial by April 14th. The court has received a plea guilty form, Mr. Burgess, which indicates that you're going to withdraw your not guilty plea, plead guilty to the charge in the indictment of aggravated possession of methamphetamine 53 felony. And so a 3-page form that has been prepared from the prosecutor's computer has a signature line on page 3. I'll hold up the first page, which has your name. I see they misspelled originally. It was crossed out, spelled correctly. Name matching your first did that. Anyway, I'll put that up there. Recognize that as being the first page of your plea agreement.
Yes.
All right, and on page 3, there are signature lines, and about halfway down the page, there's a sentence that says, "I enter this plea voluntarily." And immediately below that, there's a signature which appears to be Chad Burgess. I'll have that camera, and is that your signature there?
Yes, sir.
When did you sign this agreement, Mr. Burgess? All right, did your attorney go over this with you and explain it to you and answer any questions that you had? And do you understand that I signed it in that it's an agreement to plead guilty, which means there's not going to be a trial. The next step in your case will be a sentencing hearing.
I think a plea.
Yeah, I know. It means there won't be a trial, and then the next step in the case will be a sentencing hearing. You understand that? Okay. Now, did you have enough time to fully consider this matter before you made this decision?
That sounds about right to me. Something else.
Okay, well, I'm just asking you, do you rush or pressure in any way in doing this? Okay, you've had enough time to think about it, and this is what you want to do. You're comfortable with your decision. Okay? And are you entering into this agreement to plead guilty voluntarily? Okay, I'm not sure you understand my question. My question is, are you doing this voluntarily, or are you doing it because you're being forced or coerced into doing it against your will?
Yeah, I'm doing okay.
Okay, thank you. Now, the agreement states on page 1 that you're going to plead guilty, as I said, to the charge of aggravated possession of methamphetamine under 2925.11 Revised Code, 53 felony. And it states that you understand that the maximum prison term that the one that's imposed would be 12 months. The minimum would be 6 months. Could be a fine of up to $2,500 and a license suspension of between 6 months and 5 years. You understand that? And are you facing any felony charges anywhere else? Are you on probation, community control, post-release control, or parole for a felony? Alright. Now, under the law, Mr. Burgess, if you should ever be sentenced to prison for this offense, the law provides that upon completion of that sentence, it's possible that the adult parole authority would choose to put you in what's called post-release control for a period of up to 2 years. It's optional, they don't have to, but they'll make that decision. If they do, you would be supervised by a parole officer that firmly says for up to 2 years. If If you were not complying with those conditions, they could return you to prison to make you serve an additional period of up to 1.5 of the prison term for one or more violations. But if you are convicted of another felony while under post-release control, then in addition to whatever sentence the judge in that new case would impose, that judge is also authorized to sentence you in this case for committing that violation while under post-release control to an additional term of 1 year or whatever time is left on that period of post-release control, whichever is greater. You understand that? All right, that would have to be served consecutively, by the way, to the new sentence. Now, I'm not required to sentence you to prison for this offense. I can impose what's called non-prisoner community control sanctions, which means that instead of going to prison, you can be put under the supervision of a probation officer for a period of up to 5 years under term set by the court. If during that period of time the probation department felt you were not complying, they would have to file a written notice of that to the court, serve a copy upon you, and you would have a hearing. You would be entitled to have an attorney to represent you, and if the outcome of that hearing was you failed to comply, at that time, the court would revoke your community control and then send you to prison for 12 months and fine you $2,500. You understand that? All right, now the charge alleges that on or about March 20, 2021 in Miami County, you knowingly obtained, possessed, or used a Schedule II controlled substance with methamphetamine. So that is the charge. Now, do you understand what it is the state said when, where, how they alleged you did it?
Yes.
And you understand the possible penalty for that offense?
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense that might try to raise a trial, possible outcome of the trial with your attorney?
Yes.
Are you satisfied with your advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
No.
All right. Has anyone threatened you to make you plead guilty here today?
No.
Now, on page 2, toward the bottom of the page, there's a couple of sentences that read as follows. We're putting it in bold and underlined. Finish letter plead guilty to the indictment, state defense, trying to recommend community controlled substance abuse treatment. Is that your understanding of the agreement?
Yes.
Anyone promise you anything other than that to get you to plead guilty?
No.
Under the law, Mr. Burgess, the matter of sentence is up to the judge, not the party. So even though there's an agreement, that should be your sentence. Once I've heard all the information presented to me, if I decide that's not the correct sentence, I could sentence you to a prison term and fine you if I felt that's what should happen. You understand that?
Yes.
You hold any license or certificate from any state agency that regulates any profession or occupation?
Forklift license.
A what?
Forklift license.
Okay. But other than that, nothing? Okay. All right, now you have certain constitutional rights you must understand before I can accept your plea of guilty. First of all, you have the right to have counsel. Ms. Whitt was appointed to represent you. Now, I didn't appoint her simply to work the case out, but to provide any defense that could be available under the law you would like her to provide. So if you decide you don't want to do this, she'll still continue to defend you, represent you, including a trial if that's what you want. You understand that? All right, now in the Constitution, Mr. Burgess have the right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that reside in this county that are selected for jury duty under your trial date. After they're selected, the evidence will be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict whether or not to stay true to guilt through without. And that verdict would have to be unanimous, and then all 12 have to agree on a guilty or not guilty verdict. Now, if you decided you didn't want to have a jury trial, that you didn't want to plead guilty, you can waive in writing. Waive means to give up. And that means that instead of having a jury trial, you have a court or bench trial, meaning the judge would be the one to hear the evidence by the law and decide whether or not to stay true to guilt, or come back. You understand that? Right, under the Constitution, you have a right to confront witnesses against you and cross-examine your attorney, which means that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else was present. After the prosecutor was done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that will be to bring out evidence that help your side of the case. You understand that? Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like you say. So if you have witnesses you're not certain are going to come in voluntarily, your request for issue of court order doesn't speak. And that forces those witnesses to come to court to be able to testify for you, even though they don't want to be there, which is the same way the state's witnesses are required to come to court. You understand that? Under the Constitution, you have the privilege of self-determination, which means you cannot be forced give evidence in this matter at any time, including the trial. No one's ever made you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even going to comment about it except in one situation. That is, if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that? Right now, in the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the defense charge by proven beyond a doubt. What that means is that the burden of proof is on you to show you're not guilty, but simply because you've been charged. In fact, under the law, you're not required to put on any evidence that you're in defense. You may, but it's not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt, prove beyond a reasonable doubt on every essential element of the defense charge, which is the highest burden of proof that's known under the law. You understand that? Right now, originally entered plea not guilty, that plea denied the allegations in the indictment, denied you committed any crime, and exercised or revoked all the rights such as described for you. Change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives up all the rights that I've just described for you today, except the right to have an attorney. Always have a right to have an attorney no matter which plea, without exception. If guilty. Waives up your right to a jury or court trial. Waives up the right to confront witnesses against you and cross-examine for your attorney. Waives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. Waives up the privilege of self-incrimination because you say you're guilty, that's what you define you're guilty. And waives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, and finally, waives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you the maximum sentence under the certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all that? And are you a U.S. citizen, Mr. Burgess? Now, do you have any questions about the charge or possible penalties? You understand them? Have any questions about the plea agreement? You understand it? Have any questions about the constitutional rights I've explained? You understand those? Have any questions about the plea of guilty, what it means, what will happen if you enter that plea? You understand? Alright, is there anything you'd like to speak to Ms. Wood about before we go any further? If you do, I can put you into a breakout room where no one else will be able to hear you or see you. Alright. Do you have any questions about anything that I've explained to you this morning? This afternoon? Is it your decision then, Mr. Burgess, to go forward with this agreement and plead guilty to the charge that we just discussed in this plea agreement?
Yes.
All right, then as to the charge that alleges that on or about March 2021 in Hyman County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine in violation of Section 2925.11 Ohio Vice Code. A 5th-degree felony carrying possible prison term of 26 to 12 months, fined up to $2,500 with possible license suspension for 6 months to 5 years. Right, the court finds, and on this date of the court, defendant was advised all his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same. Subject to Article 11, please set before the file, and found guilty of charge set forth in count 1. The case will be referred to the probation department for a pre-sentence investigation, which shall include an assessment for substance use disorder and/or mental health. And sentencing will be set for April 21st at 1 p.m. All right, bond will be continued. In the event that it's recommended that he receive residential treatment and there's a bed available prior to sentencing, the court would entertain a motion to release him to the treatment facility pending the sentencing hearing. Anything further from the council? All right, thank you. We'll need Adam Willie next from the jail, please. Okay, are you out, Leon Willie?
Yes,
Case number 22-016, State of Ohio versus Adam Leon Willie. Hearing is being a pretrial being conducted by Zoom. Mr. Willie is appearing from jail. His attorney is staying with here in her office. Appearing from the prosecutor's office is the prosecutor and Collins. Been charged with failure to register second change of address. To register second, this is the first pretrial. Final pretrial set for the 7th of April. Trial set for the 14th. Let's see, it looks like the state provided the bill of particulars yesterday, and I believe we're right about the discovery of Ms. Collins. Okay.
She request on the 14th, I think, to combine with the 15th.
All right, that has actually made it up here, yeah, I thought I saw it. It's probably still just behind Bill, no, it's not. All right, you got that, just, with.
I do, Your Honor.
All right, your discovery is to do the final pretrial. Are you anticipating any pretrial motions?
No, not at this time.
Has there been a written plea offer provided yet?
Yes, Your Honor.
All right, is your client aware of that?
Not yet, I will be out there by then.
Okay. All right, are the answers on this case? All right, we'll see you on the 7th of April then, Mr. Willie. Thank you. Tessa Holsinger next, please. All right, case number 22, CR 64, State versus Tessa Holsinger. You're Tessa Anne Marie Holsinger. All right, Ms. Holsinger is appearing by Zoom from the jail for the trial. Her behalf of her office is Attorney Daniel Witt, representing the state's prosecuting Attorney Collins, defendant charged with aggravated trafficking and aggravated possession of methamphetamine. Matter set for final pre-trial April 13th. Trial date on April 28th. All right. I don't see any discovery requests in here yet. Did you request discovery, Ms. Witt?
I did, and I received it.
Yeah.
She requested on the 14th, and we provided our discovery, and the particulars on the 15th.
All right. You just made pre-trial motions. They also provided.
Yes, Your Honor.
Did you find where that's yet?
Not, Your Honor.
All right.
I'll be out by then with it.
All right. Are there any other matters to discuss on this case?
No, Your Honor.
All right. We'll see you at the next trial then, Ms. Holsinger. Thank you. All right. Kayla Cheney. All right. Are you Kayla Cheney? All right. Their case is case number 22, CR 25. State of Ohio versus Kayla Cheney. And I believe I also see it right now here, Kayla Ison. Which is it, man?
You know, I sometimes have the interview changing, I never choose the name.
Okay. All right.
Her last name on her CCA is Cheney.
All right. Hold on. There's a 20% here.
Yes, but this, I don't think it's.
Oh. Oh, okay. All right. Gotcha. All right. Thank you. All right. This is a pre-trial. You conduct by Zoom, representing the defendant is their attorney Dennis Kirk. He's appearing from his office representing the state prosecuting attorney. Well, the defendant's charged along with 6 other co-defendants in this case. He's charging counts 25, 26. This is a first pretrial, and I believe the final pretrial is,
Today's the final, Judge.
okay, this is the final pretrial, the trial session is 11, all right. So discovery complete.
It is from the state.
It is, Your Honor. I did go over my final 14-day rule, and with March 28th will be the last day she's taking action. I do plan to go back and see her again tomorrow in jail, and they may have it resolved. If we do, we'll request a plea hearing. If not, we'll do the second jury trial.
All right. There's no pretrial motion.
No motions. I was discovered this morning. We will service complete.
All right, well, so there is a written plea offer.
There is, and I have communicated that with my client. It did recently change, and I've updated her on the change in the offer as well. And she's taking that under consideration.
All right. Anything else that we need to discuss?
There, Your Honor.
All right. Then your attorney will be in touch with Miss Lyson. Thank you. All right, Joshua Rowland, please. Is Jacob right in custody or is he on?
Your Honor, he's gonna appear by Zoom. He's in treatment.
Okay. He's not logged in yet.
And he had a hearing. I advised the bail earlier this week. He has a hearing that started at 1 in Clinton County. And when that hearing is over, then he was instructed to log in Zoom.
Okay. All right, are you Joshua Rowland, appearing from the jail?
Yes, sir.
All right, this is case number 22-066, State of Ohio versus Joshua Rowland. Hearing is pretrial being conducted by Zoom. Final pretrial is set for April 13th, and trial is set on May 9th. The principal defendant is Dennis Kirk, appearing from his office by Zoom, and appearing from the prosecutor's office, the prosecuting attorney, and Collins, County State. Defendant is charged along with a co-defendant in counts 1 through 4, 2 counts of aggravated trafficking, and 2 counts of aggravated possession. I see that discovery was provided, I believe it was provided. I guess that's just a request, we're still picking within discovery. As had been provided, Mrs. Collins does not make the file.
We provided, requested on the 9th, you can apply on the 9th.
Okay. Anticipate any pre-trial motions, Mr. Kirk?
And not at this time.
All right. Has there been a written plea offer provided yet?
Yes, Your Honor.
There has not related to my client.
Okay. Are there any other matters need to be discussed at this time?
No, Your Honor.
All right. We'll see you in the next pre-trial then, Mr. Rowland. Thank you.
Yes,
All right. We have Brandon Pettiford there on the screen. And it's case number 22-CR-45, State of Ohio. Brandon Pettiford. And you're Brandon Pettiford? Okay, where are you appearing from, Mr. Pettiford? Okay. All right, well, this is case number 22-CR-45, State of Ohio versus Brandon Lee Pettiford. This is a pre-trial being conducted by Zoom. Mr. Pettiford's attorney is Dennis Kirk, who is appearing by Zoom from his office. And representing the state is a prosecuting attorney Collins, appearing from her office. And Mr. Kirk, you and your client both agree with this matter being conducted by Zoom rather than an in-person hearing.
Yes, Your Honor.
You're all right with that, Mr. Pettiford?
Yes, sir.
All right, now, since you're not in court next to your attorney, if at any time you would like to discuss something with him, just let me know. I can look two of you in a breakout room, or you can talk, and it'll be just two of you on the screen. No one will be able to see you or hear you, okay?
Thank you.
All right, Mr. Pettiford is charged with when 2 counts of aggravated trafficking methamphetamine, 1 in the vicinity of the school, 2 counts of aggravated possession of methamphetamine. Matter is set for trial on April 14th, and I have been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea and plead guilty to count 1 of the indictment. On this page, this is not very good copy, tax quality, I should say. It's got a lot of dots on it, but I can read it. This is a plea of guilty agreement, 3 pages long, that the prosecutor's office has prepared from the form. The first page, Mr. Ford, I'll hold up here and show you on the screen, and you recognize that form?
Yes, sir.
All right, and on page 3, there are signature lines, and not quite halfway down, there's a sentence that reads, "I enter this plea voluntarily," and then there's a signature, Brandon Pettiford. I'll show that to you. Is that your signature there on the screen?
Yes, sir, it is.
All right. It looks like this was faxed to someone on the 16th. I'm not sure who. But anyway, when did you sign this agreement, Mr. Pettiford?
This morning, Your Honor.
All right. And if you had a chance to talk with your attorney and to explain everything on this form before you signed it,
Yes, sir.
and you understood that the agreement to plead guilty, which means there won't be a trial, and the next step in your case is going to be a sentencing hearing.
Yes, sir, I understand that.
All right. And do you think you had enough time to fully consider this matter before making this decision?
Yes, sir, I do.
You've not been forced into doing this against your will or threatened in any way to get you to do this?
No, Your Honor.
All right, now the agreement states on page 1 that you're going to withdraw your not guilty, plead guilty to the charge, and count 1, aggravated trafficking and methamphetamine in the vicinity of the school zone, under 2925.0381, a third-degree felony. It further states that you understand that the maximum term for that could be 36 months, minimum will be 9 months. There's also a possible fine of up to $10,000, and there's a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, you faced any felony charges anywhere else?
No, Your Honor.
And are you currently on probation, community control, or post-release control, or a felony from any jurisdiction?
Felony probation, Your Honor.
Okay. All right, does anybody know what that case is?
Yeah. On the discovery, it's case 19 CR 0202.
All right. All right, Mr. Pettiford, was this offense committed while he was on community control?
Yes.
Okay, all right. And so, if you plead guilty in this case, Mr. Pettiford, then one of the conditions of your community control in the 19 CR 202 case is that you not commit any additional felonies. And if you do, then that would be, or convicted here, that would be a violation of that case, and that looks like that was a 5th-degree felony. So, in addition to the possibility of 36 months in this case, you could also be sentenced to 12 months in the other case, right, other than that, any other cases that are either that are pending against you or that you're on probation community control for? Felonies.
No, Your Honor.
Under the law, if you're convicted of this offense, and sentenced to prison, once you plead prison term, the adult parole authority could put you in what's called post-release control supervision for a period of up to 2 years. They don't have to. It's optional, but they'll make that decision. If they do, you'll be supervised by a parole officer in the terms they set. And if they find that you don't comply, they can return you to prison and make you serve an additional period of up to 9 months for one violation, up to a maximum or cap of half of the prison term for all violations. But if you committed a felony, and in addition to whatever sentence the judge in new case will impose upon you, that judge could also sentence you for committing that offense while post-release control. In this case, one additional period of 1 year, whatever time's left on the 3 years or on the 2 years of post-release control, whichever is greater. That occurs, that must be served consecutively with the sentence in the new case. You understand that?
Yes, sir, I understand.
All right, now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control, meaning that instead of being sent to prison, you would be put under the supervision of a probation officer for a period of up to 5 years in a term set by the court. And during that period of time, you were found or alleged to have violated those conditions. The probation would file a notice of that with the court in writing. You'd be provided a copy, and you would be afforded a hearing and be entitled to have an attorney. If the outcome of that hearing was you failed to comply, then at that time the court would community control, then sentence you to prison for 36 months upon you $10,000. Understand that?
Yes, sir.
All right, now the charge alleges in count 1, Mr. Pettiford, that on or about March 16, 2021 in this county, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in the vicinity of the school zone in violation of Section 2925.0381 Ohio Vice Code. So that's the charge that aggravated trafficking methamphetamine in the vicinity of the school. So, now do you understand what it is the state said you did, when, where, how they alleged you did?
Yes, sir, I do.
Do you understand the possible penalties for that offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible offenses you might try to raise in trial, and the possible outcome of the trial with your attorney?
Yes, I have.
Are you satisfied with his advice and confidence in this matter?
Yes, I am, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, I'm
And any threats remain to make you plead guilty here today?
no.
On page 2, there are several lines printed in bold and underlined, and I'll read as follows. Defendant shall enter plead guilty to count 1, state dismissed remaining counts. State defense jointly recommend 30 months incarceration. State will oppose judicial release of residential substance abuse treatment after 6 months incarceration. Defendant agrees to pay back fine money to Huntington County Task Force in the amount of $120. That's your understanding of the agreement?
Yes, sir.
They won't promise you anything other than that in case you plead guilty here today.
No, they have not.
Now, under the law, Mr. Pettiford, the matter of sentence is up to the judge, not the parties. So even though there's an agreement that you should get 30 months and then get judicial release after you serve 6 months, neither of those recommendations are binding on the court. So if you plead guilty, I could sentence you to any sentence in between the 9 and 36 months that's authorized by statute. And if I do sentence you to prison, just because the state doesn't oppose it doesn't mean you're going to get it. I'll still make that decision once I've seen all the information that's presented to me. You understand that?
Yes, sir, I understand.
All right, and all right. Now, do you hold any license or certificate, any state agency that regulates any profession or occupation?
A mission certification for corporate training.
Okay.
I'm able to hold my corporate classes and license.
All right. Does that come from the Department of Commerce, or is that a trade organization?
That's a trade.
Okay. All right. So that's private organization, it's not state government. Okay. All right. Now, you have certain rights you must understand before I can accept a plea guilty from you, Mr. Pettiford. First, you have a right to have counsel, and Mr. Kirk is appointed to represent you. Now, I wasn't sent to work the case out, but to provide any defense that could be available under the law that you wish to provide. So, if you decide you don't want to do this, you'll still be represented by counsel, and it'll defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to a jury trial in this matter, in which 12 people will be selected from a group of citizens that are that live in this county. And after the 12 are selected, then the evidence will be presented, they'll be instructed on the law. Then that jury would have to decide by unanimous verdict, 12 have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up the right to have a jury trial. And in that case, you'd have to hold a court or bench trial. That means instead of a jury hearing the evidence, would be the judge who gave the evidence, apply the law, and decide whether or not the state proved your guilt by proving beyond reasonable doubt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you and cross-examine through your attorney. What that means is that the witnesses against you have to come in court and testify for you, your attorney, and anyone else present. After the prosecutor then asks you questions, your attorney will ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have any witnesses you're not certain going to come in voluntarily, at your request, the court issues a court subpoena, and that forces those witnesses to come to court, be able to testify for months to, even though they don't be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir, I do.
All right. Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make a testimony. The prosecutor can't, the judge can't. You have a decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. The only thing you can comment about it, except in one situation, that is if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
All right, now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the charge. So, what that means is that the burden of proof isn't on you to prove that you're not guilty of this charge simply because you've been accused. The burden's on the state to prove that you are. And so, at trial, you're not required to present any evidence in your own defense at all. You may, but you're not required to. Whether you present any evidence or not in your own defense, burden of proof will remain upon the state to prove your guilt or prove beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof is known by the law.
Yes, sir.
All right. Now, originally, your plea of not guilty was court. That plea denied the allegation, denied you committed any crime, and exercised or revoked all the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation, admits it's their crime, admits you committed that crime, and that plea waives all the rights that I just described today, except the right to have an attorney. Always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty, waives gives up the right to have a jury or court trial. Waives gives up the right to confront witnesses against you and cross-examine your attorney. Waives gives up the right to use the power of the court to compel or force witnesses to come forward to testify on your behalf, the same as the state. It waives gives up your privilege against self-incrimination because if you say you're guilty, that's what you can find you. And also, waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you. It also subjects you to being sentenced immediately by the court. Finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sent you the maximum sentence rather than certain circumstances, you can file an appeal, but that would have to be filed in 30 days if your sentence ends up being filed. Do you understand that as well?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge and possible penalty?
No, Your Honor.
You understand?
Yes, sir.
And you understand that conviction in this case would be a violation of your community control of other case, and likely to result in that being revoked and you being sentenced to prison on that charge.
Yes, sir, I do.
Any questions about the constitutional rights of your claim?
No, Your Honor, I do not.
You understand?
Yes, sir.
You have any questions about the plea agreement?
No.
You understand that?
Yes, sir.
And again, you understand that the recommendation on the sentencing and judicial release is not binding on the court.
Yes, sir, I do.
Guilty, what it means, what will happen if you enter that plea here today.
No, Your Honor.
You understand it?
Yes, sir.
All right. Yeah, do you need to speak to your attorney about anything before we go any further?
No, Your Honor.
Do you have any questions about anything I've explained to you today?
No, Your Honor.
Then it's your decision to withdraw your not guilty plea guilty to the charge, count one, as discussed in this plea agreement that I just.
Yes, sir, it is.
And as the charge allegedly on or about March 16, 2021, Miami County, Ohio, you did learn to sell or offer methamphetamine, Schedule 2 controlled substance in the city of school zone, violation section 2925.03A1, hired by aggravated trafficking of methamphetamine in the city of school zone, third degree felony, carrying possible prison term between 9 and 36 months, a fine of up to $10,000, a mandatory fine of $5,000, a possible license suspension 6 months, 5 years. I plead.
Guilty, Your Honor.
All right, the court finds on this day, court defendants advised of all of his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Please accept the one filed. The defendants found guilty of count one. Counts 2 to 4 are there. Now, normally I would proceed to sentencing forthwith, but Mr. Pettiford is not present, and your bond conditions were you were to be at the Massey house during the pendency of this action, and I have a note here from Mr. Argina that you called on Friday at 1 o'clock and said you wanted to leave and go somewhere else. You were told that you were supposed to stay at Massey house, but you left and you went to First Capital, which I'm not quite sure why, since there's an agreement here to plead guilty, you get sentenced. So I'm not going to sentence you today, because I wonder if you're going to show up. So we're going to set a sentencing hearing next week. Kirk, schedule is on Monday.
My schedule?
No, I don't care about your schedule. Your schedule is my schedule. Whatever I say, your schedule is what it is. Mr. Kirk, tell me what your schedule is.
I have my calendar in front of me.
All right. Are you available Monday morning?
I have a dentist appointment at 8 and a sentencing hearing at this court at 10. Otherwise, I'll be available any other time in the morning.
Monday afternoon, 1 o'clock. Saturday.
1 o'clock would be good.
We have hearings, Brandon Eagle, and Quadrilation.
All right, let's do 2 o'clock. 2 o'clock Monday. So you'll be here, Mr. Pettiford, at 2 o'clock Monday. And also, we'll deal with the probation violation in the 19 case at that time too. So, Sergeant, if you would have the officer go ahead and get that prepared and filed so that we can deal with that at that time. All right. So, Mr. Pettiford, I expect to see you here. If you don't show up, you can imagine the recommendation that you were able to get in the plea agreement will probably not be followed. And it may not be followed anyway, but it certainly won't be happened if that happens. You understand?
Yes, sir. I'll be there.
All right. 2 o'clock Monday.
Thank you.
Yes, sir.
I don't think we're going to need it since he's ratified. I'll just put it through. All right.
Brittany Henry.
Jacob Wright, they have him up there.
He's the Zoom.
Somewhere, I think.
Oh, okay.
He's the one that had court in
He's the
Clinton
one
County.
that, I was contacted just yesterday and advised that he, had a case in Wilmington at 1 p.m.
Oh, that's right. All right, so he's not even gonna call in.
He's supposed to log in on Zoom. He was provided with Zoom information according to the treatment court.
See which cases are in person. Are you gonna be handling those, Ms. Collins?
I think Adam is coming over, so Jake Wright is going to be Zoom now.
He was set up Zoom originally, I believe. But yes, apparently because he's in Wilmington, unless, well, I don't know what time he can get here. Why don't you text him and see, Mr. Kirk, where he is. If he's coming back through town, then he might as well come to court.
I'll see if we can get in touch with him.
All right. Okay, I'll go ahead and leave this open for the time being and just mute, and, we'll deal with the cases we have here, in court, so. Mr. King is not here yet, Ms. Collins.
He's coming.
Coming,
He's
all right.
moving out.
All right, thanks. All right, Ms. Hapner, we'll cases first. Oh, yeah, we have, yeah, Miss Henry's supposed to be at 2 o'clock, I believe, by Zoom as well. So, I'll just leave this open to you. All right, Dennis first. All right, this is case number 22CR22, Dave Ohio versus Devin Sparks. Oh, the prosecutor, never mind. Okay, case 22CR22, Dave Ohio versus Devin Sparks. Present on behalf of the state's assistant prosecutor King, present on behalf of the defendant, Mr. Hapner, and our lead Devin Sparks. Yes, sir. All right, now Mr. Sparks is charged, so we'll quick minutes of Mr. Sparks in counts 17 and 18. This is a final pretrial, and the trial date is set for April the 11th. Now, is the discovery complete on both sides?
I have not made reciprocal discovery yet to the state. I'll get that in.
It's completed in state court.
All right, I'll get yours in by Friday. And there are no pretrial motions, brother?
No, Your Honor.
All right. And there's been a written plea offer provided.
There has, and my client is aware of that.
All right, is he rejecting that?
We're not rejecting it. At this time, I'm not available on April 11th, the trial date, but I believe we'll be, I've asked my client to give me his thoughts on that plea offer, whether we'll be making a counter offer, or whether we'll be proceeding to trial. And he is not yet made his mind on that. So he's not ready to offer, but I'm not available on April 11th, so I'd have to ask for a continuance of the trial date. That's my regular day at Fayette County.
Okay. See, I think several of these others pled guilty.
Yes, Your Honor.
Are there any of them,
Let's see.
any of the other co-defendants set for that trial that day?
Tim Bryson is pled guilty, Brian Collins pled guilty, Gary Sparks pled guilty, Gail King pled guilty, as well as like Captain Sparks.
All right. So we don't have to worry about joint trials then? At this point?
I don't anticipate any other.
Right. Mr. Sparks been on bond for most of the time, hasn't he?
If you have it, Your Honor.
Alright. So don't have any big problem. Alright. Let's see, the date was, April 11th. Let me, calendar here. I don't know what our schedule is, I know we've got a lot of cases. See, we have a trial starting the 28th, right?
Yes, Your Honor.
That could be 2 to 3 days.
At least two.
This trial, it's going to look like May 12th, how about May 12th, is that,
That's my day in Washington courthouse.
okay, what about the 9th?
That's my probably stay up there.
Okay. What about, April 28th?
I've got a jury trial in Fayette County that day.
May 31st.
Yeah, it works.
We've got that,
All three again.
let's go ahead and see the last one. Alright, May 31st. That'll be at 8 a.m. And I'll set this for a final pre-trial head for, 4 and 2 p.m. Alright, so you won't have to be here on the Mr. Parks. Keep Mr. Attorney, if matters, resolved, we'll get it, done for them. Alright, Douglas Peterson.
Your Honor, I was expecting this to be by Zoom. The arraignment entry says it's by Zoom. And when I got back to my office from Fayette County for this morning, I was expecting to have a Zoom invite and I didn't. So I suspect that he was probably waiting for a Zoom invite.
That was not on the list here.
I understand that, but the arraignment entry says it would be by Zoom.
Right. Okay. Let me, that first thing, like that. It's the first pre-trial, isn't it?
It is.
I think at the time they said it, he was in jail.
Yeah, and I think that that's what we were all expecting.
Mr. Peterson was set as a Zoom hearing, I believe at the time of the hearing. And, after session, he got a, notification, a Zoom invite. I don't know if we did or not, but,
Yeah, I can.
all right, did we get any, email information on him sending him about? They're supposed to collect that information in jail.
Good luck.
All right. Do you have any information on him?
I don't, because I've not had contact with him. I went out to the jail to see him and he'd been released. But I haven't heard from him.
Has he been reporting, Mr. Argino?
I'm sorry, who was going?
Douglas Peterson?
He came in once for a visit, and he's scheduled tomorrow, or today or tomorrow.
Okay. Well, if he comes in, tell him to, get in touch with an attorney. I'll go ahead and reschedule this as an in-person hearing.
Thank you.
And we'll continue this until, Monday. Are you Monday afternoon?
It's the 21st. Yeah, and the afternoon's fine.
All right, 2 o'clock. We'll continue this until 2 o'clock. And, let me know if he shows up or not. did not collect an email for him. Yeah, that's why he didn't get an invitation. All right. Okay. Let's see, I have, Mr. Parker here from the jail, so his client's in the jail, so do that.
Recording in progress.
All right, Mr. Parker's, signing in, so. All right, thank you, defendant, Brittany Henry, you are Brittany Henry, appearing there in jail. All right, this hearing is a pre-trial being conducted by Zoom, Henry's attorney, Mr. Parker, is appearing, his office in Perry State, is the prosecuting attorney Collins. The, defendant is charged in, 22 CR 12, aggravated possession of methamphetamine, 5th-degree felony, and 22 CR 43. He's charged with, 3 counts of aggravated trafficking of methamphetamine, 1 in the vicinity of the school, with 3 counts of aggravated possession along with forfeiture. This is a first pre-trial. We have a trial date, or a live pre-trial date April 13, and a trial date of April 28. Now, has there been any discovery yet?
Yes, Your Honor, go ahead, Ms. Collins.
We provided discovery back on February 22nd.
Oh, well, I didn't look that far up, okay.
Judge, I just recently received a USB drive yesterday with additional discovery.
Okay.
I will need to follow up, but there were a few files I got corrected that I'll need to follow up with the Miami County Prosecutor's Office. I did meet with Ms. Henry yesterday to review the paper discovery I received, and I intend to get out next week and get the findings of the videos as well.
Okay. You just made a pre-trial motion, Mr. Parker.
Your Honor, I did file a motion for disclosure of confidential informant, and I also, should this matter go to trial, will file a motion for a laboratory technician testimony. Should we get there, I would note that I spoke with the prosecutor Collins yesterday. She was gracious enough to let me pop in and meet with her. We discussed the offer, which I need to discuss with this.
Okay. All right, Ms. Collins, did you have something you were going to say about the discovery?
I did. Did you just bring the USB yesterday? Is that what you were doing here?
So we had sent a prior USB, 16 gigabytes, we received notice from the prosecutor's office that was large enough, and we sent an additional 32 gigabyte. I just happened to be over in that area, wanted to review what discovery I had up to that with Ms. Henry prior to.
You know, guys, I don't really have time to listen to this. If you guys, you got your discovery, that's all that matters. Okay.
Yeah, sure.
Now, are there any other matters in that need to be discussed at this point?
Maybe the rule on the confidential informant.
Okay. The court's position has been in these cases is that it'll be disclosed if there's going to be a trial, as long as the court, as the state still takes the position that you want to keep that identity. Has it been disclosed in any other case at this point?
Her CIs?
Yeah.
Yes.
It has been disclosed?
Yes, and the way we've done it is just file a notice with the court, like an additional discovery with notice that says we have disclosed the name to the attorneys of the CIs.
Okay, that's for trial purposes?
Yes.
Okay, that's in the case of 28?
Yes.
Okay. All right, and so that's just the counsel only disclosure at this point?
Yes.
Okay, all right.
Well, I mean, they can tell their.
Yeah, now they can't because they're going to trial.
Right. And they can tell the record of the court's file.
Okay.
Just a notice that says that we disclosed it.
Okay. Generally, the court waits and grants that 14 days prior when there's going to be a trial, Mr. Parker. So at this point, I'll reserve ruling on it until that time. But if you're going to go to trial, you'll definitely get it 14 days in advance. So we'll take that back up on the 13th of April.
Yes, ma'am.
All right. Anything further?
No.
All right. Thank you.
Thank you, Your Honor.
All right. Now I think that's the last one.
Yes.
Okay.
Well, no, is it Jacob Riken?
Oh,
Oh, that's right, yeah.
Minutes from being done up in Clinton County, so when it log on or when you drive over to this.
Have him log on.
Okay.
Okay, so I'll just go ahead and mute this and we'll wait for him to log in.
Recording stopped.
Okay.
All right, John Richards. All right, we have two cases for the court, all the same defendant. Case number 21CR180, State of Ohio versus Johnny Richards, and case number 22CR11, also State of Ohio versus Johnny Richards. Here on behalf of the state is Assistant Prosecuting Attorney King, on behalf of the defendant is Attorney Capner. And are you Johnny Richards?
Yes, sir.
All right, the defendant entered a plea of guilty in 21CR 180 to breaking and entering into theft, both of the 3 felonies. And then in case number 22CR11, he entered a plea of guilty to aggravated possession of a fentanyl related compound, a 53 count. The court referred the matter for a pre-sentence investigation, and I have received that and reviewed that. Also, the case was referred to drug court, and I have received an application for it to be admitted to the drug court docket, along with a letter from the surgeon indicating that he met clinical criteria, and is currently at Massey House since February 17th. Now, each of the attorneys could read the summary. Yes, I.
State's had an opportunity.
I'm aware, Your Honor.
All right. Thank you from the state.
Only what's contained in the plea agreement, Your Honor. In the 21CR180 case, there is restitution in the amount of $5,110.80 joint and several with the co-defendant payable to Doug Howard.
$5,110.80
$0.80
to
Doug Howard.
Happy. I think I disclosed previously that Mr. Howkey built bars for me, and
You might have said that with the co-defendant.
okay, I can't remember.
I don't remember hearing it.
Okay, well, I just wanted that disclosure. Apparently, it never occurred to me when I did this before. I know I did it on the other one, but just when Mr. Richard, Mr. Howkey, back when I was in practice, I represented him and his family, and then he was on the school board, and he built a barn for me about 12 years ago, just did some work about 2 years ago on it for me. So, I do know him. I know that if that's, you feel more comfortable with another person, I don't understand that. And I should have disclosed it back then. I didn't realize that I had. So, I'll talk to you about that and see if there's any issue.
We're okay, Your Honor.
All right?
We're fine. Yeah.
Okay. All right. Thank you. All right, Ms. Hapner, on behalf of the defendant.
Thank you, Your Honor. John has had a drug issue, and that's what, obviously, with the possession case, that makes pretty self-evident, but with the breaking and entering and theft, that's also, his drug problem led to those issues. He is facing that. He spent quite a bit of time in jail prior to going to the Massey House through a municipal court case. So by the time he got to Massey, he'd been clean for quite some time. So he's been in Massey for roughly a month now, and he indicates to me that it's going well, that he's now at the point where he can see family and have contact with them, so he's progressing along, which is good. And I also discussed with him the restitution amount. I will admit that I was surprised that it was that high when I got it, and asked Mr. King if there had been an insurance claim or anything. Apparently there was not. Mr. Richards, however, did not at all. He said, no, my bad, I have to pay for it, and he accepted it, which I think is showing that he is manning up. He's facing his responsibilities. So I've explained that to him. I've explained to him what joint several is, and so we would ask that you do admit him into the drug court docket, and I hopefully this will give the adults behind him, complete drug court, get clean, do the job, pay his restitution, be on the right path.
All right, Mr. Richards, anything you'd like to say?
Yes, sir.
Well, the price of tools nowadays, it must price $5,000. Yeah, it doesn't take a whole lot to get there. I've reviewed the pre-sentence report and your application, and you understand, Mr. Richards, that I don't make people go into drug court. It has to be their choice. Drug court docket is different from the regular community control docket. In regular community control probation, the goal is to keep you going to prison. And so there are restrictions put on, and you're supervised, but the hope is that you're going to do most of it yourself, take advantage of things on your own, and be able to avoid many violations. The drug court docket is different in that the focus is on the person's recovery, becoming sober, remaining sober, and there are a lot of services that are available and assistance and resources that are available in terms of housing, placement, job, training, help with things that are issue qualified to be employed. And it is much more intense. And there's daily call-in for drug testing. There's and you get tested like in the first stage 3 or 4 times a week, and you're given a window to come to the testing. Now, being at Massey House will work for that, so they can do the testing there. But once you get in transitional or on your own, you'll still be required to do that for a while. There's a lot of more restrictions in place, including curfews, and then you have goals that are set for you. You have to develop their goals. So there's a lot of things that put a lot more responsibility on you. And so there's no point in putting somebody in that against their will. If they're not willing to do the work, then it's not going to do on their own. Then it's not going to work. And so it's just a waste of everybody's time. So if your goal is simply to stay out of prison and nothing else, then that's not going to be the court. If your concern is your sobriety, then it is. Because given your history, if you stay sober, you're not going to commit any more crimes. And so that's why we emphasize that part of the program. So you have to fill out an application. Ms. Berger went over everything with you. Are you sure this is what you want to do?
Yes, sir.
Okay.
I'm pretty confident myself. I was kind of one
All right. Well, then the court will approve your application and issue it to the drug court docket. It is ordered that you be put on community control, drug court docket for a period of 3 years. The conditions of the community control are that you, well, first of all, you have to comply with all of the program requirements and conditions that are in the program description that she went over with you. You had copies of it, you get the copies again of everything. And you'll have to comply with all those conditions. You'll be required to obey all laws, all restrictions, conduct yourself in all market at all times. You'll be required to report when and as directed, be truthful in all statements you make to the probation department regarding your conditions. You'll not be permitted, you must keep an informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility of any jurisdiction, or may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. Now, you're not permitted to purchase, possess, own, use, or have under your control any firearms, ammunition, dangerous ordnance, weapons of any other kind. And I also note that due to your conviction of 22 CR 11 for the drug offense, that would be a violation of both federal and state law, even after you complete your sentence, because that's a legal disability unless you are able to get that restored in a separate legal proceeding. And if you didn't, then you had those items, that would be a felony, subject to prosecution of state and federal law. You're not permitted to purchase, possess, use, have under your control any kind of controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance of drug abuse has effects similar to those of controlled substances of drug abuse, or any instrument, device, or thing that may be used to administer them or prepare their administration, unless you have a prescription and you have it in 24 hours. I'll also tell you that prescriptions are tracked through the state system by one of our members of our advisory committee and pharmacists, and you're required to make sure any doctors you go to are aware of being in drug court before they prescribe medications. You may not obtain a medical marijuana card on the drug court document. You're not permitted to, or you are required to submit drug testing when as requested by the probation department, as well as any members of the treatment team, any of the fighters you're seeing. You're not permitted to purchase, possess, use, or have under control any kind of alcoholic beverage, nor may you be present in places where they're sold, being consumed, being otherwise lawful. You're not permitted to associate with your co-defendant or any other person as a criminal record, a member of the gang, or any other criminal group, or any person has in the past or good in the future, which you commit a criminal offense or violate these conditions unless that's proven in writing by your supervising officer that apply to any family members that fall within that definition of any, unless you were living with them immediately before the commission of this offense. Now, after the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another person without written permission. Must report any contact with law enforcement on any arrest, citation, conviction, or the charge of violating the law on later than the day that occurs. Must provide your supervising officer with financial information records so your ability to pay any fees, fines, or costs period due and restitution. If you are referred by any probation treatment people in for an evaluation or assessment for further treatment or therapy or training or programming of any sort, you'll submit to that. There's a recommendation for that treatment or programming. Here's your role in this successful complete that. You make payments, pay restitution, and I'll leave that by information. Because we don't want people working early in phase one. Focus on recovery. You'll be required to comply with all of the conditions, as I said, in the drug court program, which are adopted as part of this order. Must comply with your treatment plan as recommended. You'll be required, or by being placed on control rather than being sentenced to prison, you're deemed to sent to a search without a warrant. Your person, residence, vehicle owned by you, or used by you, or any property place where you're found, or where you're under your control of any kind, any officer of the probation department. In case number 21CR180, you're ordered to pay a restitution amount of $5,110.80 to the county joint several with the co-defendant. That will be paid through the picking restitution escrow account. And you pay any service fee that's required for that. You also will pay the court costs and make payment arrangements and court. And if you don't do that, then the court would order you to complete service, keep your credit, you carry your work, and a higher rate set by the court. You carry your work, will reduce your judgment by that amount, so pay. Now, in the event that it's alleged that you have failed to comply with these conditions, there will be a written notice of that filed with the court. You give a copy. You're entitled to have a hearing if you're represented by an attorney. And if the outcome of the hearing is that you have failed to comply, at that time, the court will terminate the drug court docket, transfer you back to the written docket, revoke your commission control, and in case number 21CR180, you'd be sentenced to 24 months, 24 months, and fined $5,000. And in the 22CR11 case, you'd be sentenced to between 6 and 12 months and fine. Leads the sentences ordered by the court. The law provides that the golf parole committee has the option, if they choose to exercise it, to place you on post-release control supervision for a period of up to 2 years. Which means you'd be supervised under the terms they set because of course not law. They determine that you have not complied. They can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for one violation, up to the maximum half of the prison term for all violations. But if the violation is a felony, then in addition, every sentence of judge in any case proposed felony, that judge is also authorized to sentence you. In this case, with additional period of 1 year, or time left on that 3 years of post-release control, whichever is great. If that occurs, or 2 years of post-release control. If that occurs, that must be served is anything further from council?
No, Your Honor.
All right, you're, now off of pretrial supervision, which you are under regular, court supervision. And see Ms. Sturgill here, she'll give you time that you need to see the, probation officer and, report to them. All right, thank you. Okay. All right, Glenn, oh, Mr. Rapp, was assuming it was a Zoom hearing, so, nobody will allow me in here shortly. All right. That's your last case?
It is, Your Honor. If you've got a minute though, we've got Katrina Haynes set up tomorrow morning for her probation violation. She was just seen yesterday by the psychiatrist who wants to prescribe Resveratrol and also Vivitrol. So I was just checking with Mr. King and he's fine. Asking if we can continue that because I'd like to see her get settled with those prescriptions before we have the hearing if that's acceptable to the orders.
That's fine. Send a, motion and then we're to do that.
Sounds good.
Oh,
Thank you.
please, maybe?
Yeah.
All right. She's in jail, isn't
She is,
she?
yeah.
Yeah, all right.
Thank you.
I think that's what we're concerned about that.
Exactly.
Okay, so that's what we're spending on our team training. All right. And we want to finish this hearing and then we'll do, actually I got Mr. Wright and Mr. Kirk. Okay, State of Ohio versus Jacob Wright. Case number 22 CR 35. You are Jacob Wright, appearing there on your phone. All right. Mr. Wright's attorney is Dennis Kirk. He's appearing out of his office, and the prosecuting attorney also appearing from her office. The defendant is charged with 2 counts of aggravated trafficking methamphetamine, 2 counts of aggravated possession of methamphetamine. I believe this is the first pre-trial, final pre-trial set for the 13th of April, and the trial set for the 28th of April. Looks like discovery has been provided by the state. Have you done your discovery yet, Mr. Kirk?
I did, Your Honor, I filed it this morning,
Okay. Do you anticipate any pre-trial motions?
but not this time.
All right, and has there been a written plea offer provided?
Yes, Your Honor, I'll be ready for you.
Is your client aware of that?
He is aware.
Yeah. All right. Are there any other matters then that need to be discussed at this point?
Not from the state.
Yeah, Your Honor.
All right. Your next hearing will be in person, Mr. Wright, on April 13th at 2 o'clock. Okay. All right. You go ahead and log off. Thank you.
Thank you, Your Honor.
All right. Mr. Rapp, is your client there?
Yes, Your Honor.
All right. Case number 22 CR 38, State of Ohio versus Leslie A. Howard. This is a pre-trial being conducted by Zoom.
Hold just a second, Judge.
Oh, I'm sorry, one more right again. What you didn't have there?
I must not. What's the case number again?
22 CR 38. Leslie A. Howard. WESLEY.
This is in your own.
The next one is by in person.
Okay. I didn't say file record at all.
Okay.
Recording in progress.
All right, State of Ohio versus Wesley A. Howard, 22 CR 38. This is a pre-trial being conducted by Zoom, and appearing on behalf of the state is prosecutor Collins, and appearing on behalf of the defendants, Attorney William Rapp, and your client is there with you, Mr. Rapp.
Yes, sir, that's
All right,
correct.
if you can show him on camera for the record, please.
Yes, sir.
All right, thank you. All right, the defendant's charged with aggravated trafficking, methamphetamine, and aggravated possession. And then there's also a forfeiture specification. This is a first pre-trial. It's like the first one was convicted, the original one, and sentence continued. And then, final pre-trial set for April 13, and we have a trial date for April 28. I don't see any discovery requests. Is there any discovery requested on this case?
No, Your Honor.
Mr. Rapp, you're not going to ask for discovery?
Yes, sir.
All right, well, this was arraigned on February 3rd, I believe. Local rule says you request discovery at arraignment forthwith, so get that filed immediately, Mr. Rack. I'm not one of those judges that lets discovery just lie, and then somebody comes in, pre-trial says, well, we don't have it yet. So we need to get this rolling. At this point then, are you aware of any pre-trial motion?
I'm not judge.
All right. And I assume there's not been any kind of written plea offer yet.
Yes, there has.
Oh, there is? Okay, sure. Quite aware of that?
I've had some, we had discussion, days, this is what we offer on the other case would include this one, so there's been discussion, I'm not aware of our plea offer.
Okay, March 11th. We sent that March 11th. You emailed me about it and asked me another question about it.
Okay.
Well, you know, we have a 14-day rule, Mr. Brad, and I continue your trial once, so we're inside that window now on that case. The case is set for trial 28 for, today's the 16th,
That's
so
not the
I know, it's not this one. What I'm saying is, plea discussions on that one appear to be over because, we've already sent out jury notices and,
Judge, I am aware of that email, but I still stand fast, I don't believe a specific number, was offered.
well, I don't really care. It's not up to me to, I don't really want to know what the offer was or anything about it. I just want to know if there was one. That's a standard question. So, so right now, in this case, about the next pre-trial, as soon as we get your discovery in, we'll do another issue. All right, are there any other matters to discuss then this time?
That's a mistake.
Well, I have no matters to discuss on this case, but I have worked very hard in the last couple of days to file a couple of matters related to 21 CR 0164, which is also jury trial set less than 2 weeks now. Would you like to hear from me on that?
Well, the deadline to file your motions was the final pre-trial. I haven't seen any. You haven't filed a motion yet?
I believe it's just been filed in the last 10 minutes.
All right, well, I would not know that, so what is it?
I filed a motion, first of all, for leave to file motions out of time. And it's based on the newly provided discovery that was filed in the case second trial in 21 CR 0164. I believe it was filed on March 8th. It was received and reviewed by me this Monday. And having received that additional discovery packet, I felt compelled to file a couple of motions. One is the motion to dismiss, an alternative to appoint a special prosecutor, as well as a motion to exclude all evidence contained in the additional discovery packet filed in March.
To do what regarding the special, the discovery packet?
That would be a special prosecutor.
Yeah, but he said something about all the discovery in the additional packet.
I filed a separate motion to exclude all evidence contained in the additional discovery packet that I was provided. That's timestamped 2022.
And on what basis?
Well, for one thing, Judge, I think that probably to review it, the reality is I just received basically all of the discovery that would normally be associated with 22 CR 038. I received that as additional discovery on our case. And like I say, I had 2 days. I received this and reviewed it. So when we talk about being timely, I do cite the local rules also as the discovery is provided, expected. I just got this. I just looked at this evidence on Monday. I just received.
This discovery is continuing, and as soon as I made a deal with his co-defendant, I disclosed.
I was gonna say, what is this evidence that's a problem? Because it's 20 days prior to trial, that seemed like plenty of time with the DEA to deal with it. What is the reason that you think that,
Well, Judge, it's a whole new case packet. It's the, for one, alleges, as it relates to the case from the trial, it's uncharged misconduct. And I don't believe it's admissible, one, frankly, because of the untimeliness of the way that it was provided. Two, I don't believe it's relevant. Three, we also argue it's not admissible under 404. Finally, we argue it's not admissible under 403. But there are additional matters involving that investigation that I was not aware of that has caused me to file this motion to exclude all the evidence, as well as either to dismiss or, in the alternative, to appoint special prosecutor. I'll be happy to schedule a hearing with the court any day next week. I'll try to move everything around to address it.
Well, I want to know what the special prosecutor is.
yeah, I mean, what would be the required, how could I possibly disqualify a prosecutor versus a conflict of interest?
I believe it may be a conflict of interest in that two at least, Highland County Prosecutor's Office are now listed as witnesses in this case.
They're listed as witnesses, but I don't tend to follow them.
Who's that, investigator?
No, it's Adam and Molly, they went out with them on the buy.
Oh.
They watched the buy.
They want to buy, and then also there was an identification made by Assistant County Prosecutor Adam King that was then relied upon by Special Agent Sanders, who was right, who then relayed that information to the other detectives. And as a result,
He may have had a point, had I not made, with his co-defendants who will testify against him that he got the drugs from his client's hand. I don't need any of these people back.
Okay. Well, I have Monday morning available.
So when you access my calendar on the phone, you may not see me for a second, but
All
I'm
right.
still here.
All right.
Do you hear me on?
Yeah, I can hear you. There's some motion, his thought was filed in the last 10 minutes. Okay, well, go downstairs, have to be my back, or even.
I have two matters Monday morning that I can have rescheduled. What time?
Well, I can do it anywhere between 9 and 11.
The later the better for me, frankly.
Well, I need to be done by 12, that commitment due.
How about 10 o'clock, Your Honor?
10 o'clock.
That's also good with this time.
All right, now, just check with the assignment commission, we don't see those motions yet, so they need to be, faxed up here or emailed so they can get filed, so we can get that same way, do it to the prosecutor as well, so she can have those as well.
Yes,
I
sir.
don't know either.
But they were just faxed. I have the confirmation email. My assistant just brought them up. And
Okay.
I didn't know, frankly, to be able to address this so that I could tell you that both the state and the court has received this by the time of this preaching.
Okay, well, I haven't seen it yet, so she just checked the docket, it wasn't listed, but I told her to call downstairs, so. All right, so Monday at 10 a.m., and that'll be an in-person hearing.
I'll be there.
All right.
Thank you.
Thank you. You found it? All right, good. All right, I think that's it. All right, Joshua Corcoran.
That's right, gentlemen.
Yeah. All right, this is case number 21 CR 205. State of Ohio versus Joshua P. Corcoran. Present for the State as Assistant Prosecutor Attorney King. Present on behalf of the defendant is Daniel Witt, who are Joshua P. Workman.
Yes, Your Honor.
All right, the defendant is charged with aggravated possession of methamphetamine and properly concealed firearms, motor vehicle, aggravated possession of drugs, and forfeiture. This final pretrial trial date of April 11. The court has received a plea guilty form for a criminal gin case that you are going to withdraw your not guilty plea and plead guilty to counts 1, 2, and 4. This is a 3-page form that has signature lines on page 3. At the top of the page 3, there's a sentence that reads, "I entered the plea voluntarily." Immediately below that, appears a signature, appears to be saying Josh Workman. That's your signature I'm looking at.
Yes, Your Honor.
And when did you sign this document?
Just a few minutes ago.
All right, and when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, Your Honor.
And is this something that you would talk to Ms. Webb about before coming up here today?
Yes, sir.
And so when this was presented to you, did you feel you were surprised or unaware in any way?
No, Your Honor.
All right, you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
Are you entering into the agreement to plead guilty voluntarily?
Yes, Your Honor.
Now, the agreement states then that you're going to plead guilty to count 1, aggravated possession of methamphetamine, under section 2925.11 of the Higher Revised Code, a 5th degree felony. Count 2, properly handling of a firearm, under section 2923.16B of the Revised Code, a 4th degree felony. And properly handling of a firearm and motor vehicle. And then forfeiture specification under 2941.14.17 and count 4 of the indictment. Now, it states that you understand that as of the first count, that's a 5th degree felony which carries a possible prison term between 6 to 12 months and maximum fine of $2,500 and possible license suspension of 6 months to 5 years. Count 2 carries a possible prison term between 6 and 18 months and a fine of $5,000. And so, if convicted of both of those offenses, those sentences could be served consecutively, and if the maximum is opposed to each case, I think the maximum possible sentence would be 30 months. And it could be a maximum fine of $7,500. You understand that? Are you facing any felony charges in any other jurisdiction?
Yes, sir.
Are you currently on probation, community control, or parole, or post-release control, or any company?
Just what you have to
Just
do.
here. All right. Now, under the law, if you are convicted of this offense, or these offenses, counts 1 and 2, by the way, count 4 is, would simply result in a loss of property that's mentioned there, in which appears to be a Mossberg 9mm handgun. There's no jail sentence or fine for that. You understand that?
Yes, sir.
Now, under the law, if you're convicted of these offenses and if you're sentenced to prison, then upon completion of that prison term, it is possible that the adult parole authority might choose to place you under post-release control supervision for a period up to 2 years. They don't have to do it, but it's optional, but they'll make that decision. The court has no say in that. If they do that and you fail to comply, then they would have the right to return you to prison as a sanction for that non-compliance for an additional period of up to 9 months for one violation, but the maximum would be a cap. It's half of whatever prison term was imposed and served for all violations. Now, if you committed a felony while in post-release control supervision, then in addition to whatever sentence the judge in that new felony case would impose, that judge could also sentence you for committing that offense under post-release control supervision in this case to an additional period of 1 year or whatever time is left on that period of 2 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively as a sentence in that new case. Understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison. for this offense, or either of these offenses. Instead, I can impose what's called community control, which means instead of going to prison, I put under supervision of a probation officer for a period of up to 5 years. Now, if during the period of time, and the condition to be a 7, if during that period of time, probation department felt that you were not complying, then they would file their notice of that or serve a copy on you. You would be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your control and then sentence you to prison for a total of 30 months and fine you $7,500 for the 2 offenses. You understand that?
Yes, sir.
All right, now count 1 alleges that on or about June 6, 2021, in this county, that you did knowingly obtain, possess, or use schedule 2 controlled substance with methamphetamine in violation of section 2925.11 of the Fire Advice Code. And so that would be the possession of methamphetamine, the 5th degree. Count 2 alleges on or about December 17, 2021, in this county, you did knowingly transport or have a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator or passenger without leaving the vehicle in violation of section 2923.16B of the Fire Advice Code. So that's the 4th degree felony with a possible prison term of 6 to 18 months and fine of $5,000. And then count 4 alleges that on or about December 17, 2021 in Miami County, Ohio, you had in your possession a Mossberg MC-21 9mm handgun, subject to forfeiture due to its instrumentality in the commission facilitation of the offense, as defined in 2941.14.17 of the Advice Code. Now, you understand what it is you've been charged with by the state in those 3 counts, what they said you did, or how they alleged you did it as each.
Yes, sir.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues you might have in the case, and possible defenses you might try to raise at trial?
Yes, sir.
And are you satisfied with your attorney's advice and confidence in this matter?
Yes, sir.
Are you under the influence of any type of drugs or alcohol at this time?
Yes, sir.
And then press to make the issue plead guilty here today.
Yes, sir.
Now, page 2, there's a little over 2 lines printed in bold and underlined that read as follows. Finish line plead guilty to counts 1, 2, and 4. State was dismissed count 3. State defense jointly recommend community controlled drug treatment and agrees to forfeiture of gun. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that issue plead guilty here today?
Very good.
Now, under the law, Mr. For the matter of sentence is not up to the parties, it's up to the court. And so, even though there's an agreement that you should get control or probation on these offenses, once I've heard all the information is presented at the sentencing hearing, if I decide that's not the correct sentence, I could sentence you to prison for between 6 and 30 months, fine you $7,500. And there would also be a license suspension on count 1, 6 months and 5 years. Understand all that?
Yes, sir.
Right. Now, do you hold any license or certificate from any state governmental agency that regulates any profession or occupation?
Yes, sir.
Okay. Now, you have certain rights, must understand, before you accept your plea. First, you have the right to have an attorney who's appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that could be available to you that you wish to provide to the law. So if you decide that you do not want to plead guilty, that you would rather defend against these charges, then she will continue to represent you, including your trial, if that's what she wants. You understand that?
Yes, sir.
Right now, in the Constitution, Mr. Corcoran, you have the right to have a jury trial on this matter, in which 12 people would be selected from the citizens that live in this county that are summoned for jury duty on your trial. The evidence would be presented, and there would be instructions on the law. And then that jury of 12 would have to decide by a unanimous verdict, all 12 would have to agree on whether or not to stay true or go of any of these charges. Now, if you did not want to have a jury trial, if you did not want to plead guilty, you could waive in writing, and that in a legal sense means to give up, the right to have a jury trial. And in that case, you would have what's called a court bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would follow the law, And the judge will decide whether or not state proof to go back to account for that. You understand that?
Yes, sir.
And under the Constitution, you have a right to confront witnesses against you in open court, then cross-examine your attorney. What that means is that the witness against you has to come into court, testify in front of you, and your attorney, and anyone else who is present. After the prosecutor is done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have right to use the power of this court to tell or force witnesses to you, just like the state. So if you have witnesses you're not certain going to commit voluntarily, it's your request the court issue the court that's a subpoena. And that forces them to come to court and be available to testify if you want them to, even though they don't want to be here. Which is the same way the state's witnesses are forced to come to court. You understand that?
Yes, sir.
And Mr. Worker, under the Constitution, you have the privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time before you trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way or any person at any time. And no one's even allowed to comment about it except in that situation. And that is if there's a jury trial and you do not testify. The judge instructs the jury that because that is your right, they cannot consider that for any purpose. You understand that?
Yes, sir.
And under the Constitution, you're presumed innocent until proved guilty by the state of Ohio on every essential element of each of these three charges. I prove beyond reasonable doubt. So what that means is that the burden of proof is on you to prove that you're not guilty of these charges simply because you've been accused. In fact, under the law, you don't have to run any evidence at trial at all. You may, but you're not required to. Whether you present any evidence in your own defense or not, the burden will remain on the state to prove your guilt by proof beyond reasonable doubt on every essential element of each of the three offenses, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you entered a plea not guilty, Mr. Corcoran, and plea denied the allegations in the indictment tonight you committed a crime and then exercised or revoked all the rights that I just described for you. Now, if you change your plea from not guilty to guilty as to these three counts, that plea is the complete opposite of the not guilty plea. The guilty plea admits the allegations in those three counts in the indictment, admits that they're crimes, that you committed those crimes. And that plea waives up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you plea. But with that exception, your plea of guilty waives up your right to a jury or courtroom. Waives up your right to confront the witnesses against you, cross-examine through your attorney. Waives up your right to use the power of the court to tell or force witnesses being in court to testify for you saying to the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find guilty. Waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove that you're guilty. It also suggests you be sentenced immediately by the court. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you to maximum sentence or other search circumstances to file an appeal, that would have to be filed for 30 days for sentencing after you filed. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Do you have any questions about any of these three charges?
Very well.
You understand?
Yes, sir.
Do you have any questions about the plea?
Yes, sir.
You understand?
Yes, sir.
You understand, again, the recommendation of the sentence is not binding on the court.
Yes, sir.
Do you have any questions about any of the constitutional rights I've explained? You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Very well.
Do you understand?
Yes, sir.
All right. Is there anything you'd like to speak about?
Yes, sir.
Do you have any questions about anything we're talking about here today?
Very well.
All right, then, as to the, or then it's your decision to go ahead and enter pleas guilty to these three counts. All right, then as to count one, which alleges that on or about June 6, 2021, Highland County, Ohio, he did knowingly he did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine fifth degree felony carrying possible prison term of between 6 to 12 months and a fine of $25 and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Then as to count 2, that alleges on or about December 17, 2021, Huntington County, Ohio, you did knowingly transport or have a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator or passenger without leaving the vehicle. Violation section 2923.16B in our revised code. Charge of improperly handling firearms in a motor vehicle. Violation section 2923.16B. A fourth degree felony carrying possible prison term between 6 and 18 months and fine of $5,000. How do you plead?
Guilty.
And then as to the fourth charge, which alleges that on or about December 17, 2021, Huntington County, Ohio, you had in possession of Mossberg MC 21 9mm handguns, serial number 014130 MC, subject to forfeiture due to the instrumentality and commission of facilitation of the offense defined in section 2941.14.17 of our revised code, which would result in the loss of the weapon to the state. How do you plead?
Guilty.
All right, thank you. Proceed. All right, the court finds that on this date in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to criminal weapon as to all 3 counts. Defendant is found guilty of counts 1, 2, 4. Count 3 is dismissed. Court will order a pre-sentence investigation which shall include assessment for substance use disorder, treatment, and/or mental health issues. And sentencing will be set for May 4 at 9 a.m. Bond will be continued. You can see Mr. Argino over here about kind of when we get the report for your pre-sentence interview. That's a different officer, I believe, that we're doing that. I see I didn't have reports here that tell you that initially you weren't reporting. For another, when you did it, refer to another chance. And then back in, I guess that was today. Then there's another one that came in that said that you did come in yesterday and indicated you are going to be assessed on March 30th. There another chance. So, you've been testing positive, so you need to look at that. And there is a they have available for you if they recommend it. It doesn't actually treatment or if they go or not. But if there is a recommendation, then my suggestion would be that you do that because if that's what you need. And if you're serious about this, then you do it before it makes you. Okay, anything further, counsel?
No.
All right. Your son was available.